तो एक जो गोल्डन रूल है, व्हाट इज प्लीडेड कैन ओनली बी आर्ग्यूड। बिना प्लीडिंग के आप कोई आर्गुमेंट कर नहीं सकते। दैट इज द थंब रूल, गोल्डन रूल है। प्लीडिंग कैसी होनी चाहिए? बहुत प्रिसाइज होनी चाहिए, टू द पॉइंट होनी चाहिए। जो क्वेरीज हो सकती हैं उसका आंसर प्लीडिंग में होना चाहिए। जब आपके समक्ष कोई वकील, कोई क्लाइंट आता है तो उसकी जो प्रॉब्लम होती है उसको फॉर्मुलेट करके प्लीडिंग में हम कैसे उतारें, और जितनी बात प्लीडिंग में हो केवल उतनी ही बात आप आर्ग्यू कर सकते हैं। उसके आगे आर्ग्यू करना प्रोफेशनल मिसकंडक्ट होता है। जितना हम आर्ग्यू करते हैं जरूरी नहीं है हर बात पे कोर्ट डिसीजन दे, ये मैंडेटरी नहीं है। उसमें से हो सकता है कुछ चीजों पे ही कोर्ट डिसीजन दे, उतना ही बाइंडिंग होता है। तो आज इस प्लीडिंग के आर्ट के लिए हम सबसे पहले हमारे लोकप्रिय सीनियर अधिवक्ता, बहुत सफल अधिवक्ता, हम सब के बहुत सारे प्रेरणा स्रोत आदरणीय डॉक्टर एल पी मिश्रा साहब, सभी युवा साथियों के लिए जोरदार तालियों के साथ आदरणीय एल पी मिश्रा साहब।
Chief guest of today's this academic function, and who fully fits in my definition of a good judge. There are two, both of them I feel that fit in Honorable Mr. Justice Pawar, also guest of honor today. One of the characteristic of a very good judge, to my perception, is that he should be so able that he can hold whatever he wishes to hold. And when I say so with a great responsibility about Mr. Justice Jasprit Singh. Because while performing the constitutional obligation in Article 226 of the Constitution, where a thing which may be legal but still might be requiring to be struck down, a thing which may not be legal, lawful, statutorily lawful, but consciously that may be just and proper for the parties present before the judge, even illegal order or judgment can be upheld. And in my perception, that beauty I have been enjoying in the court of Honorable Mr. Justice Jasprit Singh, wherein that I have always found and noted the distinction between law and justice. There is very fine distinction, and that is present there. Therefore, I regard him as a very good judge and today in our camp of judicial fraternity. Honorable Mr. Jasprit Singh. Another quality which I feel that is in abundance in Honorable Mr. Justice Pawar, and that is that if you happen to sit inside a courtroom or argue a case, and when you come out you must feel, a lawyer should feel, or if he feels, irrespective of any seniority, irrespective of any years of experience, that today while sitting in the court or while arguing a case, he has learned something which he did not know earlier. That is another beauty of a judge. In my respectful perception, that beauty is in abundance in Honorable Mr. Justice Pawar. The young and energetic President, our President of both Bar Association, Mr. Rakesh Chaudhary. Another young person, Mr. Rajawar, Senior Vice President, very successfully and effectively conducting the proceedings as General Secretary of our Bar Association, Mr. Pleadings. Tripathi. Amrita Tripathi has virtually opened the subject while his introductory address being given to us. At the outset, before coming to this subject, I would like to thank, with an exception and an objection, to Mr. President Rakesh Chaudhary and the members and office bearers of the Executive Committee of the Upper Bar Association for giving me an opportunity to be here with you. Objection is that I have been described as one of the special guests. I am part and partial of you all here present. You all present here are source of strength to me by rubbing shoulders with you times and again. Whatever I am here, I am today because of you only. Therefore, I am not your guest. I am just a small family member of this big family of our Bar Association. Now coming to the subject under the Think Legal, the art of pleadings and art of advocacy is such a subject that there should have been a written speech. The problem with me today is I don't have a written speech. The subject deserves that. But if the deliberations of today are put in records by way of any journal, etc., to be published by our organization, I assure that whatever I say and whatever I don't say requires to be said, I shall be putting in writing and shall be handing over to our President or the General Secretary if I am required and journal is to be published. But the subject is of very wide amplitude and very great importance, and such a broad subject that requires the volumes of the book might be required to be written on that. But first and foremost, there are certain general principles which are both for art of pleadings and art of advocacy. In my perception, first and foremost quality of a lawyer should be that he or she should be a good human being. If one is not a good human being, he cannot deliver either by any quantum of pleadings, any quantum of art of advocacy to his client as one a professional deserves and is under an obligation to deliver so. The general principles are that apart from being a good man, one should be industrious. Industry is first and foremost quality of a professional, any professional, much less a lawyer and advocate. My dear friends, if you are all youngsters and our future of tomorrow, and also the shining lights in the field of legal profession, the artistic, in my perception, is of both pleading and advocacy, that if you move outside the court, you should have put in labor on a paper book in the night, in the evening past, to such an extent that if you move out, you should not have a feeling that had you seen this and this ruling as per observation of the Honorable Court, had you pleaded this and this, then result of your petition would have been somewhat different than what you have got after arguing your case and presenting your case. So industry is the first and foremost quality. Then again, even if you are industrious, if you are not honest, nothing may come to you. You may put in any quantum of labor, any howsoever industrious you are. If you are not honest to your brief, if you are not honest to yourself, if you are not honest to the litigant whom you are representing, if one is not honest to the court whom as an advocate person is addressing, if you are not honest even to the registry, then I think no quantum of pleading or art of advocacy also may be result oriented or result yielding. Then we must know the duty towards the court, duty towards the client, all these parameters are there. So far as pleading is concerned, the pleadings may be different. My Lord Mr. Justice, just please think about Chief Guest of today. Will bear me out. The standards of pleadings, though principles may be one and the same, but the methodology of pleading in a suit, while framing a plaint, in a written statement, in a replication for the trial court are different. When you come to appellate stage, in appeal or revision, the certain parameters of drafting may be totally different. In plain, you may not have to plead the legal principles. You may not have to plead the cases decided. But when you come to revisional stage, to appellate stage, then the question of law are to be given, and while giving the grounds of challenge to the already impugned before the appellate court or revisional court. Then at the higher plinth, when you come to the constitutional exercise of jurisdiction by the High Court under Article 14 essence, then two parameters are different. But one thing is common: concised material facts in order, in chronological order, should be put down at the first instance. I was told, and I think rightly so, that if one has to draft a plaint of a suit, it should be short and concise, but capable of intaking in itself any quantum of evidence you want to lead, any documentary and any oral evidence, any quantum of evidence you might be requiring to lead, that may be there within your pleading, because as Mr. Tripathi has said, that there could not be any argument without pleadings. Likewise, there could not be any pleading without argument. If you plead and don't argue, then nothing. So therefore, the statement at the first instance, the statement in chronological order, concise, brief, but self-speaking, self-expressing facts should be narrated. Then, one thing more, which many of us don't know, there was Mr. Justice, but that I have learned from him, I have no education in naming. And there was, in the criminal side, is very well reputed. He is also subsequently a judge of this Honorable Court and senior judge of this Honorable Court, also Honorable Mr. Justice Vishnu Sahai. From him I have learned one art of pleading, and that is what to write and what not to write. What to write is as important, but much more important is what not to write. But there is one caution, that what not to write, you omit to write, but then one should not be indulging in concealment of material facts. That art is the art which is not present amongst most of us, but sometimes it matters. From that date I saw, whenever my assistant counsel comes with a draft, I say, why you have written this? Mr. Pathak is smiling, he has faced many times. Then he said that it is the case of it is the case of the other side. You don't require to read that, let the other side come and say that this is true, but this is that. It is not our job. So then cut up. But caution should be there that there should not be any occasion for the other side or for the Honorable Court to ask you a question that such and such you have indulged in concealment of fact. Concealment of fact should not be there, but actually it should be seen what not to write. That is the art of thinking, in my perception. Details are there. There are many books. There is time constraints. The lot of number of journals and books, if you go through the SCC of last 10-15 years, you may get many write-ups. Recently, Mr. Karifullah had spoken on some occasion about the pleadings and advocacy, very, I think, 20-25 pages lecture given by so many things. You can get so many quotations from law justices, from legal experts, from legal philosophers. You can get without indulging into all that and leaving it to you to read. Only I say that the pleading should be concise, material facts should be pleaded, the chronological order should be maintained, in revision and appeal the ground should be there. Once my guru, professional guru Pandit Sridhar Mishra dictated me a writ petition, about 20-22 paragraphs. There were no grounds. My anxiety, I know that the writ petition should be there, thereafter grounds of challenge should be there. I queried, just expressed my anxiety, डरते हुए बहुत grounds नहीं लिखा है आपने. He looked me and said it is a writ petition, ground need not to be mentioned, ground need to be argued. Only you have to state the facts. And then he quoted so many opinions given by law experts and one or two drafts of the old days, including the of English courts. That is also now things have changed. Now one thing more has changed. I am saying I don't know. My lords, both my lords today will bear me out or will guide us. A recent trend. Things change from time to time. The standards of pleadings, standards of advocacy change from time to time. But I am saying in many writ petitions, even in appeals, along with the affidavit, judgments are being not only cited but they are annexed. In my perception, that is not a good thing. That is not required for many reasons. That may be injurious as well. Though our job is to assist the court, to reach justice, but equally our job is to honestly to speak and to argue in the best interest of our client whom we represent. If you are giving your whole thing by annexing the judgment, the other side will be in a position to just go through and to distinguish them. So that is, in my perception, that is not required. And again, such a statement made, such a pleading shall also be suffering from the verification aspect of the matter, because how to verify it? Only verification of the fact is stated in the body of the petition, may be a suit or a writ petition, have to be verified from own knowledge or from the basis of the record, the judgment, how to be verified. I don't know, but I am not clear at this stage whether the judgment should be referred to and should be annexed along with the body of the petition or not. Therefore, we shall be asking and requesting for our guidance in that regard of the matter. Now, as I